in the old Fifth Circuit, and there were 19 judges sitting there. And for whatever reason, I argued for 30 minutes and not a single one of the 19 judges asked a question. That was the worst day of my professional life. But when I look at this panel, I fear. All right, our subject is jury trial, the importance of jury trial. Andrew, why is it important?
It is important because juries represent democracy in action.
They're spoken like an academic.
True. They are not only a proven fact finder that works, but they are intimately connected to the Constitution and the constitutional values. Jury duty is Constitution duty. And I think we, as a society, have forgotten that point.
So you're hearkening back to the Constitution, that ancient document 2 centuries ago?
As well as the battle for the 14th and 15th Amendment and the suffrage battles of the 19th Amendment, which also included the right to serve on juries. People literally fought and died for the right to serve on a jury, and now how many people out there would sit and be protesting for the right for more jury duty? I don't think we'll get many.
Should I take a vote out here?
I would love a vote.
John, what do you say in defense of this ancient right?
Well, he's right, of course, but if you don't want to take a vote, you need to pitch this right, Arthur. You know, you don't need to call people and tell them you want them for jury duty. You want to call them and say, I want you to be on the cast of America's original reality show.
So, because we see it on Law and Order, we should preserve it?
No, because it works.
What do you mean it works?
It works. Juries are good at finding facts.
Yeah, they all have the requisite degrees in education to deal with a patent case and a causation issue deep in pharmacology.
If you can't make them understand that, you're failing as a lawyer. They're not failing as jurors.
That sounds nice.
Yeah.
And of course you're talking about other lawyers, not yourself.
Absolutely. No, that's your job as a lawyer. Your job as a lawyer is to make the hoi polloi understand all this hootsy-tootsie stuff you want to have.
Well, what's wrong with the judge? Got a black robe on, appointed for life?
Yeah, those are 2 things that are wrong.
That's very irreverent. That's very irreverent.
Yeah, well, Arthur, I mean, you know, if you want irreverence, you came to the right place.
What's wrong with a judge? Professionally trained, experienced. You know, juries are ad hoc instruments. They walk in off the street, we kick them back out.
That's their virtue. They don't have a lot of preconceptions about any of this stuff. If you ask judges, if people do ask judges, I ask judges, do you think you're better than 6 or 12 people in the box at figuring that out? And the judges generally say no. Judges have huge respect for juries.
That's just what they say to you, John.
They say it to people like Vidmar who do, you know, academic studies of this stuff. I don't do academic studies.
Chris, you persuaded by John's academic studies about the virtues of jury trial?
I think juries certainly are good at figuring out some things. I'm not sure that they're good at figuring out everything. But I think we're kind of missing the point to the extent you're suggesting that somebody is blaming jurors. I think the reasons that people are opting out of the jury system are really due to broader pathologies. They're not just scared of jurors. They're scared of big class actions, punitive damages. I think this is starting from a kind of Mr. Smith goes to Washington premise that, oh, you know, John has a trespass action against Mary and goes to court and gets this great jury trial. That's not the reality of the civil justice system today. So I think we have to just be realistic about what we're talking about when we have this
What does that mean, be realistic?
Yeah, Arthur, before we get too far down this road, let's start with why we need the jury. We can talk about the class actions thereafter. The reason why you need the jury is you want 12 people to decide your case. You don't want the president who appointed this judge to determine that much of your case so that you lose before you walk in the door. That's the problem.
Sal, you're paranoid.
Well, that's what we see. That's what we see as lawyers. And I do respect that the judges have a very important role. The juries can't do all of it. But I think that's ultimately the fairness issue. You want your peers to decide this case, not the president who put that judge on the bench.
And the peasants who fought King John at Runnymede 795 years ago knew that and forced him to put a seal on a document that includes Article 39, which protects the right to a jury trial for civil and criminal cases. So when Andrew said people fought and died, people have fought and died and killed around the world of all races, ages, creeds, and colors for this right. It's considered sacred and inviolable. Those are the two words used in many of the original state constitutions that our founding fathers used.
But people will fight and die to get out of a jury now. Because it's boring, it takes too much time, they have a life, and they have a job. So whatever it was in its glorious days, it's the equivalent of people around the world dying for the right to vote, while here in the United States, maybe in a good year we get 35% turnout. We just don't, the people just don't value it. Members of the jury people try to avoid it as much as possible.
It's not that the jury trial is itself boring. It's that the process of getting to a jury trial is so incredibly expensive, both for plaintiffs and defendants. And one of the reasons it has gotten worse in the last 2 decades is because of electronic media and the compulsion of some judges to compel parties to find every single last electron or neutron or whatever it is that's in those documents that can be discovered and make it available, which means that there are 5 or 10 or 50 or 100 million documents for what may be actually a very routine dispute between litigants. And that's what's causing parties to say we need to figure out a way to avoid that expense, and one of the unfortunate consequences of avoiding that expense is we're doing away with the jury trial.
But that's peanuts. You make this big point, as Chris makes a big point about class actions, about the time, the expense of all the rest, and then you say, oh, let's lock the barn door now that the horses have left. We'll ditch the jury trial.
Well, it didn't
That's
happen.
peanuts in terms of time and expense.
And Arthur,
But I don't feel strongly
arbitration.
about it. What? I hear a
Arbitration
voice.
is not
Joe?
cheaper. Arbitration is not cheaper. When you pay the arbitrators, and I've gone through 3 in the past 2 years, where we were over $500,000, if not over $1 million in arbitrator fees alone. I mean, arbitration is not a cheaper alternative.
Well, how
It is
about
an
civil
ineffective-
litigation without juries?
Well, if you want to turn it over, and every judge is going to be different, as Sal said, if it's the right kind of appointee that the plaintiff favors, you're going to be in a better shape. If it's the right kind of person that the defendant liked in politics, the defendant's going to be in good shape. A jury at least brings a leveling to it and a group of people to make a combined decision.
But I think it's important to go back to this point. The jury is at the end of the process, and the problems are with the process and the costs it imposes, and the fact is the jury isn't going to happen because of those, all of those burdens that happen at the beginning. Look at the criminal process. I mean, look at what had, we don't have to just look at the civil situation. Look at criminal prosecutions. What percentage of indicted or charged cases go to a jury trial? An infinitesimal amount, because
it's not just about money. It's not just about money and time and expense. It's not always about money, because I'll tell you why. Because something that we're all overlooking is that when you get to a jury selection, the process is fundamentally broken to the point where it should be alarming to everybody that's at this conference. Because there's someone that is in the business of being out there picking juries and going from one trial to another, the thought that when your liberty is at stake, or there's a lot of money at stake, and judges are more concentrated on whizzing through the process, and I think you'd be hard-pressed to find a judge in any federal court that isn't in a rush to pick a jury by noon the day the jury selection starts. If you're facing your freedom is at stake, or a lot of money is at stake, do you really want to go and not be able to actually voir dire jurors and go on a hunch? It's frightening that it takes so long to get to a jury trial, and then when you get there, there's this rush to get through jury selection. I mean, whether it's in the criminal context or the civil context.
Joel, does that go to the utility or propriety of a jury trial?
Who's Joel?
I mean, I'm sorry, Josh. Which would you rather have?
I think that if you actually spent the time to conduct voir dire the way it is supposed to be conducted, I think that it will work. Because are you really getting to a bias if you're not asking people what their biases are? Let me give you one quick example. I just picked the jury on the Rutgers webcam spying case, okay? And without naming the judge by name, and this is easily transferable to any civil case. So this was a case that got as much attention in the national media as any other case that catches on. And here you have a jury questionnaire, and then the judge hijacks the process. So a prospective juror comes in and says, yes, I read about the case. Yes, I think the defendant's guilty. No, I don't think I can put this aside. And the judge says, bring him in anyways. Bring him in anyways. And can I voir dire that individual? Nah, he said that he could be fair and impartial. So let's keep him on. Because there's this focus on speed.
Which would you rather have? No jury at all, leave it to the judge, or a system that does not have a perfect voir dire process?
Neither.
Well, that wasn't an option I gave you. Deborah, you spoke rather strongly, and it made me think you were against jury trial.
I'm an employment lawyer, and I'm a management employment lawyer. So you need, I know. I was going to say, I know that makes me Darth Vader to many people in the room, but I think when the amendments to Title VII went through, the deal was the plaintiff's bar said, we'll give you a cap on damages, and in turn you give us a right to a jury trial. And then immediately, management appeared to screw, if you will, term of art, the plaintiff's bar by saying, everybody's got to arbitrate. So this is supposed to be a good thing for management lawyers to arbitrate, and now we fast forward. I hate arbitration, hate it. It's expensive, and the arbitrator, and I will say, I am the daughter of a very famous arbitrator, and but for arbitration, I wouldn't have had clothes on my back. So it's not that it's generically a bad thing. But arbitrators always want to give a parting gift. They always want to give the plaintiff just a little something so that when the next time you select arbitrators, the arbitrator isn't on the, ooh, you always vote for one side list, meaning the arbitrator no longer has a livelihood. Plus, judges will boot things out where legally you got no case. Whereas arbitrators, there's no motions to dismiss at FINRA. They just hear it. There's no summary judgment, and they're getting paid. What incentive does an arbitrator have to say, we're done, you're out, it's finished? A judge does. A judge has got a wicked backlog. An arbitrator's like, let me hear your thoughts. Share with me your emotional damage. Let's discuss. And it makes my head want to blow off my shoulders and spin around. I'd much rather be in court.
There are actually numbers on this that go the other way. A professor named Alexander Colvin has studied literally thousands of cases that went to employment arbitration compared to a control group of thousands of cases that were tried in front of juries. And arbitrators in employment cases, statistically, by a very significant margin, are more likely to rule for the company than a jury would be. And in those cases in which an employee gets money, the employee is likely to get a much smaller award than they would get in front of a jury. And that those are just numbers that are established over many thousands of cases.
Well,
Yeah, and there
Deborah
are studies that say exactly the opposite, just
But
put
not
all
in
the
the
studies
employment.
on the
There's no
table.
study in the employment setting that says that. The Chamber's done a great job paying for some studies in the consumer area where there's some doubt. In the employment area, the empirical data is not even arguable.
So what does that tell you? I mean, does that tell you which is right and which is wrong?
It tells you that there's a reason that employers want to have arbitrators because they think
Unless
it's
you
gonna
have
bring
you have a
reform.
preconceived notion, you don't know which is more often right than which is more often wrong.
But in the employment setting, that's not the question. The question is, can you eradicate civil rights for employee protection through the use of arbitration to effectively enforce class waivers? That's the battleground. This discussion about whether arbitration is good or bad is irrelevant in my view. The question is, the battleground is, can you enforce class waivers in that context and essentially take away employee rights? That's what I've been seeing. That's the result of Stolt-Nielsen and Concepcion as applied in the employment sector.
And your punchline, Adam?
Well, it's got to stop.
What's gotta stop?
Well, there has to be a political reaction to the court's insistence that the FAA immunizes employers from effective vindication rights in the workplace. And that's a political discussion that has to happen.
Now, Ira, I know you've done some work on the FAA. It's your favorite statute. Yes. You want to give us about, 60, 70 minutes on the FAA?
The fact of the matter is that it seems to me that the Supreme Court has so misinterpreted the legislative intent of the FAA in 1925, and it almost seems as if it was intentional, that whatever the intent was at the time, that we're going to do the opposite, because it arose during a time in which federal courts sitting in diversity would not enforce any arbitration agreements solely on the basis of an ancient English rule that they can't give up jurisdiction simply because of some private agreement. And so the intent was simply to reverse that. There was a project of the New York Chamber of Commerce, particularly its general counsel, Julius Cohen, who both wrote the original statute and also a brief they submitted to Congress upon which was made part of the congressional record. And as far as I can tell, there was no argument by supporters against it. And basically, he said it was simple and limited. It was simply a procedural rule by which federal courts could enforce arbitration agreements. And it would not, he specifically said it would not impact upon any state laws in this area. It would not act as a bludgeon against state laws.
And it's even worse than that, Ira, because the thing was about one remedy. It was about allowing the remedy of specific enforcement of arbitration clauses, arbitration agreements. Because courts actually would enforce they'd say, yeah, we'll give you whatever damages you can prove. Now, wouldn't you love on one of these Concepcion-type class actions to say, yeah, we'll give you the damages for not enforcing your arbitration clause, but we're going to hear the case in court. I would love to see AT&T put on the case about how they were actually damaged by that.
Well,
That'd be
Mr.
great.
Concepcion, Mr. Pincus, they don't seem pleased with the havoc you have wrought.
Well, I guess I don't think it's havoc. Just a little bit on the history. There's some history to the contrary, maybe not as much, but there's some. But more importantly, way before Concepcion, the court, including Justice Breyer and the more liberal members of the court, had applied the FAA in the consumer and employment context in a wide range of areas. So I think that's sort of water under the bridge in terms of where
So they got it wrong in Southland, and we should live with it.
I don't think they got it wrong, but
Well, five sitting members of the Rehnquist court thought they got it wrong, but they said, well, yeah, but it's wrong, but we're not going to do anything about it.
Well, I don't even know if 5 members of the
there
court
were
said they got it
5. I'll
wrong.
give
But
you the
anyway,
footnote, Andy.
I guess the question is, You can talk about Concepcion as a policy matter, or you can talk about it as a legal matter. I'm happy to defend it either way. But I think as a policy matter, there's a real question in the current world of whether, and I know this will not be a popular thing to say in this room, class actions and the legal system are the best way to get the most justice to the most people. And I think that's a debate worth having, because I think there's a lot of evidence that they're not. And I know the argument that's going to be made is small claims and people will never have justice, et cetera, but in a world, as some people, I don't think they're in this room, but some people are proving right now, in a world of social media and the internet, it's possible to file arbitration claims for thousands of people and use the arbitration system to get justice for them, as well as having it available for people whose claims couldn't be classable and would have no justice.
The first time a lawyer tried to put that model to work against AT&T, you guys ran into federal court to enjoin those arbitrations.
Absolutely, because he was asking for relief. No, he was asking for relief that was class-wide. It just wasn't framed as a class action. The second time, after we won that case in about 7 courts, when the same gentleman said, I'm filing seeking damages on behalf of about 2,000 or 2,500 people, individually, we agreed that those claims were proper and could go forward in arbitration.
Hang on now. Hang on. Just, where are we? We started talking about what's so damn good about the jury trial, all right? Now what we're really talking about, just so the people in the audience know they're in the right session, this is about jury trial. What we're now talking about, indirectly, as you folks fight about Concepcion right or wrong, is why have jury trials disappeared? We heard a little bit about cost. Now we're saying one reason is everything's getting diverted into arbitration. All right? Just so that we know this is integrally related to the question of the survivability of the jury trial. Paul, you were upset.
Well, first of all, the cases are not actually being diverted into arbitration. That's a misnomer. What's happening is the cases go away. So, for example, there used to be tons of cases that were, in fact, tried involving individual cases involving car dealers and so forth, and consumer cases. As arbitration clauses have gone everywhere, what's happened in these cases, I really like Andy saying, well, you know, people could be arbitrating these cases with social media. People also could go to the moon, but there's very few who have actually done it. In 2010, the total number of all consumer arbitrations against corporations was about 1,000 in the entire United States, 1,000, okay? The small claims court that I walk by on my way to the metro handles more than 1,000 cases every month, all right? Last year, I was involved in cases where we got checks sent to our clients in class actions, and these admittedly were class actions, not individual cases, but hundreds of thousands of people. What happens to arbitrations, the cases just disappear. I saw this quote the other day. Justice Kennedy said, oh, well, you know, the reason the court's docket is so small is we're turning away these cases because those cases are all going to arbitration. It's a lie. The cases are going away.
Well, first of all, I guess 2 responses. A lot of them are not going away. A lot of them are cases. Well, a lot of them are cases where, as in AT&T and lots of other consumer companies, you file your claim and it gets resolved. Basically, you get almost what you want. Second of all, a lot of people, some of whom are in this room, have spent the last year and a half basically trying to break or limit Concepcion instead of, as I think, using that system in a way that will get justice.
Don't take it personally, Andrew. But I know you've been agitated, Barbara. You think Barbara wanted to say something? Go ahead, Barbara.
It was a sight gag. You know, I was just going to... I think what we lose with arbitration is the sunshine that we get as a society from the jury trial. The jury trial tells us who we are as a people. And when we lose that, I mean, the Rutgers case to me was a profound morality lesson for all of us. And about teenagers, young people, it taught us so much as a society. Even the Edwards trial, it taught us that we thought that was a huge waste of money, and we were ambivalent about it as to whether or not it was a campaign finance violation. We've had some incredible jury trials recently that have taught us some things. We've learned about Gupta, right? That's how the rich and powerful play. And once in a while, when you listen in the opinion of the public, he's been convicted, I assure you. They don't think it's happenstance when he walked out of the board meeting that he placed that phone call. The public knows what goes on with big money now, and we all learned something from that. And that transparency, that sunshine, is instrumental to us learning and progressing as a society, and that's what we lose when things go under cover of arbitration. The corporations get to shut down our access to knowledge, and other people's bad acts don't get aired. And, you know, some of it's a waste of money. The Edwards trial was we should put those prosecutors on trial for wasting money, as far as I'm concerned. That was much ado about nothing. But we learn from these things. The Rutgers trial, you may feel, as one of the people involved in it, that you're not happy with the outcome. As a society, I think we learned a lot about compassion, youth, errors. I mean, voyeurism. I mean, people made huge mistakes there.
I'm only unhappy. I'm not unhappy with the outcome. That's not my position on what the defendant did or didn't do in that case is, let's put that aside for a moment. What I'm unhappy with is, did the right people listen to the facts of that case? The Constitution affords us a right to litigants a right to a fair and impartial jury. And if you actually go through it over and over again, you see that whether it's a high-stakes civil rights case, I worked on a case a few years back in Houston where this gentleman was exonerated by the Innocence Project. He spent, I forget how many years in jail for a crime he didn't commit. And as soon as you want to start asking questions about people that are connected to law enforcement, and do you think you might believe the testimony of a law enforcement officer more than, say, a lay witness, and the person says, I might, and then the judge is constantly rehabilitating, so you don't really know whether or not you're left with a fair and impartial jury. It's not just about money. I know there's a big emphasis on that, but do you think a big corporation, when they're sitting there saying, do we mediate this case in a big class action case? Do we mediate this case? Do we really want to go in front of a jury knowing in the Southern District of New York that I'm lucky if I get 2 hours of voir dire, and I don't know who's going to be sitting on this jury, if they have it out for big corporations, and I won't be able to ask them a question as to whether or not they will? As a defense lawyer, I wouldn't.
All right, we have that point.
Arthur,
yes.
6 years ago, U.S. District Court Judge William Young wrote a law review article, became rather famous in the circle, titled Vanishing Trials, Vanishing Juries, Vanishing Constitution. I put it on my website, the Seventh Amendment Advocate, the first day I was open, 2 years ago Sunday. And it's fascinating. He writes, through the jury, we place the decisions of justice where they rightly belong in a democratic society, in the hands of the governed. It is fair to observe that for decades, business and insurance interests have disparaged our civil juries, while the courts have failed to defend the single institution upon which their moral authority ultimately depends. As a result of their assault, the bipartisan majorities in the Congress have restricted access to the American jury severely. Our preemption jurisprudence, long a matter for narrow construction, today is applied so broadly as to oust state courts and juries of their traditional areas of adjudication and replace them with less protective federal standards or no remedy at all. Okay. And that's basically what I've been trying to fight for 2 years. And I might add, with a growing, small but growing group of Tea Party side, constitutional conservative legal experts and members of Congress who actually want to see the jury system revitalized.
Yeah.
Some of whom used to
Bill Young is not the only federal judge who feels exactly that way. You've got Anderson of South Carolina and Brock Hornby. But notice that when Young speaks, and he is the most vocal advocate, he starts with the fact that it's also the trial that's vanishing.
That's right.
And within the trial, the jury is vanishing. Forgive me, statistics from the AO, not from me, trials occur in under 2% of all federal actions, under 2%. And jury trials occur in less than 1%. So, in a curious way, this discussion about the jury trial has to deal with the vanishing trial before you ever get to the jury.
I think that, let me throw out a couple of numbers there too, because I think we need to set the table on this issue. We've already heard some allusions to big cases, and we have to get a couple of thoughts in mind here about this is a state issue, federal issue. Federal court is 3% of all adjudications in the country, all right? The rest of them are state courts. But the big cases are in federal court. The cases that these guys are talking about, where they're big class actions that they're worried about. In federal courts, anybody have an idea the average costs of a federal case? This is going to blow your mind from the Federal Judicial Center. The average costs, including attorney's fees, discovery, and damages, $15,000 for a plaintiff, $20,000 for a defendant. That's your mean. All right? These big cases that we're talking about are outliers in that sense, but they drive a huge amount of the public debate about what should happen in courts and what trials should be and whether there should be trials.
Sure, the skewering of the facts in the McDonald's hot coffee case have really destroyed the reputation of the jury system and amongst the minds of a lot of Americans. It's an absolute travesty to see the facts of that case distorted into total myth.
So let's dump on the media.
Well, it's not just the media. Look, we can all look in the mirror. It's not just
Barbara
media.
loves the media because it gives her that transparency into these cases.
They had a lot
I
of
bet
help.
she'll go home tonight and read the latest on the Sandusky case.
I think the Sandusky case is a very important thing for us to all understand how these things, those people held that terrible tragedy in their hearts for like a decade. I mean, it's incredibly important that we learn compassion through these things going to a jury. And that went, what was that, 4 months? I mean, how quickly has that prosecution been brought? So I think the jury trial is incredibly important for us as a society. Not just, I think that the way you framed the question was, is it important to preserving the individual's rights, the protection that the individual gets? Yes, the answer from my point of view is yes, but it's also indispensable for us as a society to learn who we are and who we should be, who we should aspire to be.
Well, I would like to say from a less lofty perspective, and I'm not not as a class action, but on the daily in and out of people who are filing employment discrimination cases, this would apply to no human in this room because I'm sure that everyone has stunning respect for the legal system. But I will say
We're all above average.
right. Well, all right. At least a B minus. My world is that we routinely get letters from plaintiffs' lawyers who exploit the jury system in their demand letters, basically saying, social media, whatever, hello, my client is owed $1 zillion because of pain and suffering. This is an individual case, not class action. My brother, sister-in-law, next door neighbor is the head of the New York Times editorial page. I don't want to have to bring this to their attention, but unless you pay X sum of money by Y date at 5, I'll have to do that, which annoys me to no end. And I always think, unless there's really kind of kinky sex, it's not playing in the media anyway, so you're bluffing, because that's not that interesting. Run-of-the-mill employment cases are not that interesting. But they play that, and then when you call it on them, most plaintiffs' lawyers, they're the ones that don't want to go to a jury trial because they're contingent fee lawyers. They're chasing money over a period of years. The more they spend, the less they get unless they really ring the bell. And it's not class action litigation, so you're not shooting for the moon. So moreover, they're the ones that don't want to get there. It's not just the management lawyers who are trying to squelch the right to
Listen
love a
to
jury
what you
trial.
just said, Deborah.
I love to listen to me. Go ahead.
You just said, it's not just the plaintiffs who don't want to go to a jury. The negative pregnant in that is neither the plaintiff wants to go to the jury nor the defendant wants to go to the jury.
Because it costs too much. I always
It
say a
costs too much,
victory.
or are you checking?
No, I'm not checking, but the clients.
Well, I'd never
No, no.
accuse you of checking.
Look, Arthur, math in, math out. It's going to be cheaper to settle a case than to win. That's just the fact. And ESI costs a gazillion dollars for the reasons set forth before. One of the reasons I became an employment lawyer is, one, it's street smarts more than law, and two, the documents used to look like this. Now you get every BlackBerry tweet, Facebook message ranging from, honey, you forgot the milk, when you're looking for, you know, I want to fire you because you're old and ugly. It's very expensive, very time-consuming, mostly none of it's related, and you say to your client, I can get you out for 50, or you can win for 400. Well, guess what? Get out for 50.
Okay, so in our catalog of why is it we only try less than 2% of the cases, and why is it that jury trials are less than 1% of the cases? Admittedly, these are federal statistics. What have we got? We've got, there's a diversion into arbitration because of contract clauses. Paul would say it's a slow road to oblivion, but you would say it just makes economic sense for both sides of the equation to settle rather than pursue either to trial or to jury. You would add trial is expensive. I don't think anybody believes that, so I'll ignore you.
My point is not trial is expensive. My point is getting to trial.
Oh, getting to trial is if there's any expense,
But
but
unintended consequences. You want to give plaintiffs and defendants equal opportunity for information, and then all of a sudden this new universe of information becomes available. The same rules apply. Steve Sussman has an outstanding article on his website about how you could actually reduce discovery and get to trial to be fair to both sides. Everybody should read Steve Sussman's article. It makes a lot of sense. We need to get our hands around the problem of why it is so incredibly expensive to start and get to trial.
Didn't federal trials start to disappear before ESI was an issue? As I understand it, Congress started federalizing a bunch of drug crimes in the 1980s. All these things that had always been state cases suddenly became federal cases because there was this fight between the Democrats and the president over who was more serious on crime. So the next thing you knew, every other drug case that used to be a state case was now a federal case. The number of criminal cases in the federal courts shot through the roof. It's about the same time that the Senate stopped approving full sets of judges every year. And I think I think if you look at the statistics of when did crimes start to disappear, I think trials started to disappear decades ago, and the ESI issue is recent.
When I was in the U.S. Attorney's Office in the 1960s and 70s, I tried 40 cases in 3 years. You have to be in the U.S. Attorney's Office now for 20 years to try 10 cases. The reason why criminal cases are disappearing is because once upon a time, judges had discretion in sentencing. There was wide disparity in sentencing among judges, and some thoughtful people got the idea that maybe we should have sentencing guidelines, which were no longer guidelines, they now are rigid. And people then said, oh my God, I'm facing 40 years in prison, or I can plead guilty to a lesser offense, and maybe I'll get 2 years in prison. So criminal cases started disappearing.
I agree with that, but the point is that civil trials started dropping off several decades ago, like 30 years ago, because the federal burden of criminal cases shot through the roof. And some of the stuff about, well, gee, the reason that trials are disappearing is because now everybody has a BlackBerry. I think that is like so far statistically off the actual time of when trials started becoming 2% of all cases in the federal system.
Now, what do you think of Deborah's suggestion? I obviously edited it a bit, that nobody wants to go to trial.
I think it depends on who the people are. I think there are tons of plaintiffs who want to go to trial who right now find their cases are being thrown out by judges because their pleadings weren't specific enough, or because the judge doesn't think the expert is scientific enough, or the judge decides they're going to resolve the issues of disputed fact. I think on the plaintiff side there are a ton of people who want to bring the cases. The people who litigate against her who are so faint-hearted and weak, they're not my community.
Barry, do you agree with that last point?
I'm going to tell all the plaintiffs' lawyers you said so.
I think that you have to distinguish between, not wanting to go to trial and not trusting the jury, because I think, some people don't want to go to trial because they don't know how to try a case or because they have a bad case. But I think even if, both sides think they have a good case, I think if they think that they're going to have, a fair shot at making their argument to the jury, there are still reasons why they may not want to go to trial because the consequences of winning or losing are too great. But I think that we're really, getting off the topic, because the topic here is you know, whether they even have the opportunity to go to the jury. And I think, you know, in a lot of the cases, I think the Supreme Court, you know, in Iqbal and Twombly, by letting, you know, judges decide whether things are plausible, is taking a lot of the things away at the beginning that you know, cases that could have been established to be plausible never even get to that circumstance. So,
Is that your experience, Nat?
My experience is that I'm a plaintiff's contingency fee lawyer who represents mostly mesothelioma victims suing large corporations. And over the course of my career, my name is Nate Finch. I'm a plaintiff's contingency fee lawyer at the law firm of Motley Rice, and I represent, most of what I do is I represent mesothelioma victims who sue large corporations for putting asbestos in their products, which led to the disease that killed them. And in my experience over the past, most of those cases are state court cases, sometimes they're in federal court. And through a combination of the summary judgment rules and Daubert, which I think is an abomination and an incredible intrusion on the Seventh Amendment right to a jury trial, it is getting more and more difficult and more expensive from the plaintiff's perspective to get what really should be a garden variety tort case to a jury. And I certainly am not the type of lawyer, and my partners aren't, who just want to settle cases and duck the jury. I try cases 2-3 times a year to verdict. My partners do too. Many people in my bar do. And the defendants want to trust juries too. I don't think that just because somebody goes to law school and puts on a black robe, they're any better able to evaluate the merits of scientific testimony than a group of 6 or 12 people off the street. I think, and ultimately what the decision here is, who do you want making decisions that affect people's lives and liberty? Do you want that to be either unelected judges appointed for life, or worse still, judges that are elected who are beholden to either the Chamber of Commerce or the trial bar? Or do you want paid arbitrators doing that? I would rather put my life and my liberty in the hands of people taken off the street.
Jason?
I was just going to tell a sort of personal anecdote and then make a point. The anecdote is, I've been practicing for, 12, 13 years, and the best legal experience I've ever had was when I served on a double murder trial, and I was on the jury for maybe a month. And while it's certainly true that lots of people say they hate jury service and don't show up, I was blown away by how engaged my fellow jurors were, and I came out of that experience trusting the jury system in a real practical way, whereas previously it was just sort of all academic because I really had no sense of it. So I'll sort of transition from that to say that if I have to choose between an individual who's wearing black robes and comes with an ideology and a bias and a whole educated experience in the law, and someone who probably also has some ideology and some experience but isn't as well versed in the law, I'll take the juror every time. I think that I have more faith in their ability to make good judgments. But that's an academic question that's been debated for a long time. So the final thing I'll say, though, is this. One thing that hasn't been talked about yet, we've talked a lot about the who wins and who loses if cases aren't decided by a jury, plaintiffs or defendants, who does better, who does worse. And Barbara has, I think, very eloquently made the point that society loses if we don't have jury trials. But the law also loses, the law itself, because the law stagnates if there are no jury trials. Because when the judges, for example, are deciding motions to dismiss or summary judgment motions and trying to decide whether inferences should be applied, whether something is reasonable, whether something is plausible, whether causation can be established, that becomes a very pointy-headed academic conversation if there's no body of jury trials where people have made decisions based on real facts that were put into evidence, and we line those facts up and we say, here's what it means. And all the decisions that happened before that by judges, they're not doing that. They're making decisions based on allegations or information that comes in through summary judgment. So I think it has a profoundly negative impact on the law itself, the development of the law, when we abandon the jury trial system and go into different ways of making decisions.
Adam? I was just going to say, I would have renamed Iqbal Twombly as the Automatic Delay Act of 2008 or whatever it was. Because as a plaintiff side employment lawyer doing mainly class litigation, that's precisely the effect. And it's worse than that. Concepcion, Stolt-Nielsen, Dukes, all inevitably lead to a motion for nothing in particular, as I describe it, also known as a motion to dismiss with a request for a stay. That's every single case. It's 1 year of delay for nothing in particular because somebody wants to challenge the plausibility of the facts in our complaint, which, by the way, have grown into a short novel. We have a case against Goldman Sachs. The complaint is 47 pages long. Why? To meet plausibility. It's crazy.
You mean nonfiction book, right?
Arthur, I think nobody remembers that Rule 8A says short and plain. Short and plain, short and plain.
And Arthur, I think there's a related point to pick up on what Jason was saying, that not only does the law lose, but lawyers and the legal profession are losing in this, because we are training an entire generation of lawyers to go through their entire career with no trial experience, let alone jury trial experience. So if a litigant does get in front of a jury, do they have a qualified lawyer to lead them through that process? And there's a lot of young lawyers out here, a lot of young lawyers around at this convention, and they ought to know what they're getting into. They may go through their entire career without ever standing up in front of a jury. And so I think the entire profession loses because of this, 1% of cases going to a jury trial.
Well, you're adding, Christine, you're adding to our catalog of why are we where we are. We don't have a trial bar anymore. Well, we're
That's
not
right.
breeding the trial bar. Has anyone ever thought about why the Brits, our forebears, the people who gave us the idea of jury trial, abandoned civil jury trial? Why did they do that? Well, Lord Devlin, who should know in his book, writes, in World War II, everybody was in military service. So they suspended trials. And by the time World War II was over, and the youth took over the British barrister corps, no one remembered how to try a case, and they were afraid to do it. Now, that's not me, that's Lord Devlin.
Well, I think that goes back to Barry's point. He said sometimes the lawyer, not that they're afraid to go to trial because of the result, but they may be afraid to go to trial because they don't know how to try a case.
I think there's a big difference between the number of plaintiffs who want to have a trial before a jury, and how many lawyers who want to go to trial. And I think the question, if you were looking at the question between plaintiffs and defendants, who wants to go to a trial before a jury, you'd have a very different question that you'd or answer than if you looked at how many plaintiffs' lawyers versus how many defense lawyers actually want to try a case. I do defense side securities litigation, and I can tell you that most of the lawyers on the plaintiff side don't want to go to trial any more than I do, and whether it's a jury or not. And those cases don't go to trial because they settle, and they settle because both sides want them to settle.
Is that your experience, Sam or Sal?
Well, we don't have many trials in the securities class action field. That's certainly true. I disagree that it's about fear of trial. I think it's the economics that play the biggest part of it. But one thing we haven't talked about yet is, and that is, so when we do have successful jury trials, the courts seem to have no reluctance to take them away, to decide right after the trial, well, I'm gonna nullify that verdict, either at the trial level or the Court of Appeals level, and that's horrifying. And it happens over and over again.
I can give you a real-world securities case. My firm tried the Household International case 3 years ago. We still don't have judgment entered. We had a split verdict in favor of the plaintiffs, and we still haven't gotten a judgment entered in the case.
Why?
3 years ago. Well, we went through a lengthy claims process that took a few years, and now the defendants are challenging the claims, and we have to go through that process, and it's just taking forever.
That's why when we settle cases, the sentence is, I always say to the plaintiff's lawyer, look, real money now is better than maybe money years and years from now, and that's just true.
Well, it is true, right? When you win a verdict, and you still can't get a judgment.
Well, and if you lose a verdict, so I have the dishonor or something badge of failure to have taken a securities class action to trial, and came back with a jury verdict for the defendants, and went and spoke to the jurors afterwards. And, you know, it's a cautionary tale for a lot of reasons, but one of the reasons is, as I spoke to the jurors afterwards, they made it absolutely clear that every one of our experts went over their heads. Defense experts, our experts, completely over their heads, right? So things like emotion, or whether or not we were able to tell a compelling human story, were very pivotal. So we were barred from bringing up various issues, and our discovery was very limited. But for instance, we had made a motion in limine that they weren't allowed to bring up the law firm of Milberg Weiss, a fantastic law firm, but they weren't able to bring up the law firm of Milberg Weiss or Lirac and indictments, or that there was motion in limine practice on that. And we got a ruling that they were not able to bring that up. It was tried in the Northern District of California. It was several years ago. The issues surrounding that law firm were ripe at that time. They got it in through the expert. Have you ever worked for other law firms? Which law firms have you worked for? Oh, yes, and when you worked for Milberg Weiss, what did you do? Did you testify for the plaintiffs? So they tried to impugn credibility. They also, the defendants' life stories were told such that their philanthropy came in. One of them had escaped from Austria over the Alps. I mean, you could hear the sound of music playing in the background. It was unbelievable. One had been a naval pilot in World War II. So we had these incredible life stories, rags to riches, of the defendants that were very compelling to the jury. The expert stuff, the stock drop, the damages, the timing of the insider trades, shooting all over the jury's head. Didn't resonate with the jury at all. So I tell you, I am a champion of the importance of a jury trial, but I believe there's a tremendous amount of value to assessing your risk and the value of negotiations and settlement. There's nothing to be ashamed of for that. So just because something doesn't go to a jury doesn't mean there's a failure in the system. That could be a success in the system because you could have a mixed set of facts. The litigators actually assess their risks, and they come to an outcome that's a valuable outcome for everyone involved.
Arthur, we lose something.
We did?
We lose something. I think one of the reasons this is happening is that it's not just a battle about juries, it's a battle about what the law is. We're a common law system. If I say in here, if I ask the question, are courts supposed to make law? My guess is that most people in the room would say no. Am I right? Most people say no to that question? Yeah.
This isn't the Federalist.
But that's an idea. That's an idea that's just always been wrong, at least about state courts. Our original debates about federal courts and about lawmaking, where we didn't want federal courts to make common law because we wanted state courts to make them, and we wanted juries to make them in state law. We put in the Seventh Amendment, and which was copied from existing stuff in state constitutions and is all the state constitutions, because there were things that we didn't trust judges to do and we didn't trust legislators to do. There are huge debates in this country in the early 19th century about checking the powers of legislators through juries. We wanted this random group of people to be lawmakers, to be decision makers about what the law is in those common law claims.
Now, wait a second. Andrew is shaking his head violently.
I want to say a couple of things. First of all, I have great respect for Nadine Strawson attending all those Federalist Society convention panels, because now I know how she felt. But no, I wanted to say I was a federal prosecutor for 10 years. I tried cases to juries. I tried capital cases to juries. No one has more confidence in the jury system than I do. The Sixth Amendment is critical to our freedom. The Seventh Amendment is not. And the idea that people died in the mud so that plaintiffs' lawyers could try big-time cases to a civil jury and extort huge damages from corporate defendants is bullshit. Is honestly true. That's my view. And let me just say.
Why do you think that's pickpocket?
Well, let me just say, and let me say finally, what was the description of the jury that we just heard in that case, right? The jury didn't listen to anything about insider trading. The jury didn't listen to anything about the timing of the trades or the experts. It was all about who they liked.
They didn't listen.
Oh, they didn't understand.
I didn't say they didn't listen.
All right, well, you said it didn't make a difference to the decision. And I guess my point is, do you really want to run a national economy in the 21st century where huge decisions over patent cases, huge movements of money are made by those juries as described? I think maybe we don't.
Your description of the constitutional history of the Seventh Amendment is quite flawed. It was the only amendment approved unanimously. Article 39 of the Magna Carta specifically includes civil jury trials. It's in every state constitution, either combined with criminal juries or broken out into a separate amendment for state constitutions. It's just, I quote the founding fathers, I quote William Rehnquist, for God's sake, honoring the Seventh Amendment right to a civil jury trial. So I understand your concern about class action.
I love the candor about acknowledging that this is about how to run a national economy. I think the thing that drives the move away from a jury trial to arbitration clauses is a handful of the richest people who control the economy said, gee, we're really sick of somebody who we can't control, these jurors. You know, we don't give them any campaign contributions. We have no control over who picks them. They're just regular people, for Christ's sake.
Paul.
No, I'm totally serious about this. I'm totally serious about this. The move to arbitration clauses is a move.
Woken him up.
It is a move towards an economy that starts to resemble the Hunger Games. It is a move where the richest people in the country are trying to pick who's going to decide every decision because they can elect Supreme Court justices now. The chamber's putting tens of millions of dollars into races. They control Congress. With Citizens United, they're controlling virtually every part of the government, but they can't actually go out and bribe all these jurors. It's this random group of people who are still democratized.
Okay, can I just say one thing? I think, just to sort of talk a little bit about the effect of arbitration in reality, arbitration, the statistics that Arthur quoted about federal jury trials and federal trials have not changed dramatically in the last year or the last 5 years.
1985, 2.5% of cases went to juries. 2011, 0.73% go to jury.
But how many went to trials?
5+% in 85, under 2% in 2011.
Okay, it's still a pretty small number. It's changed.
It's known as 50%, Andrew.
But it's 50% of 5%. All I'm saying is there is not some dramatic change in the system because of Concepcion, Stolt-Nielsen, the parade of arbitration decisions. This phenomenon, to go back to what was said earlier, is about the expense of our system, and Deborah's point that any sane person, when they are told it will cost $400,000 to win, on maybe a little less on one side than the other, or you can settle the case for a lot less, are going to settle the case. And that fact has created all of the pressure for the gates that people have referred to here, Iqbal, Twombly, summary judgment, out of concern that that those costs are being imposed without any regard to whether the person who has to bear the lion's share of them has done anything wrong, because we don't find that out until the end. So I think it's nice to talk about demonizing people, but I think the reality is that we have a system whose costs are so high that getting to trial is very expensive. How many class actions went to trial before Concepcion? Infinitesimal. That's because it's too expensive and too risky for everybody.
Arthur,
so I think the question is, what about a system that changes some of these processes so that you can go to trial because the costs are less?
Well, let me inject a fact there.
Wait.
Hang on. I just want to go back to
This
the
is
criminal discussion for a minute, because I was a prosecutor too, and it's just interesting to me that you would trust a jury, as I did, to put somebody in jail for a very long time, or in your case, worse, but then not trust them to give a fair judgment against a major corporation. It's just, how do you reconcile that?
My view is, first of all, I wasn't derogating the Seventh Amendment in any way, but my view is that, except a little bit, but, and I'll say it. I mean, my personal view, and this will probably take me off any court ever, but I was already there. My personal view is that the Sixth Amendment is a critical guarantee, and interposing the citizenry between loss of life or liberty is critical. And having the unanimous jury and beyond a reasonable doubt is critical. I do not think that the Seventh Amendment is critical to the American way of life. And I think that the jury system is broken. And I do think that American business is extremely hampered by this constant barrage of lawsuits. And really, if we want to move money to people who are injured or duped, do we want to do it through our litigation system with, frankly, honestly, the plaintiff's bar making a hell of a lot of money off it?
Hey, David,
And the defense bar, too.
what about the trial lawyers for religious freedom? All the Catholic groups who filed suit a month ago demanded a right to a civil jury trial. Okay, there are trial lawyers for religious freedom out there taking advantage of the Seventh Amendment, but we're going to cut off economic trials and leave the trials for religious liberty or gun owners or property rights alone? This is what's going on with the Republican majority, frankly. This is my problem with my party.
But
it protects,
one of the things about the Seventh Amendment, though, there's a differentiation.
Only one ranter at a time. Go ahead.
Thank you.
Go ahead and finish up, Andrew.
Look, this is what I do. This is what I've been trying to do for 2 years, is make the point it's one civil justice system, one Constitution, one Bill of Rights for religious liberty, gun owners, property rights, all the other amendments of the Constitution, and economic rights. If we're going to say economic rights and property rights are equal to all these social causes, do you know, for instance, that Senator Rand Paul's bill about domestic drones basically includes a private right of action? I bet people don't know that you could actually take them to court? Big surprise. But that's where, unfortunately, the legal and political establishment of my Republican Party has gone recently, is they're protecting civil jury trial rights for certain causes and not for all. Okay? And by the way, neither Republican nor Democratic majorities in recent years have done anything to ameliorate the cost of going to trial. They're not debating arbitration or discovery, and they're not doing that in judiciary committees. What the Republicans' legal establishment has done is to hijack healthcare policy and try and instill, federal limits on med-mal awards. And it's basically Tea Party constitutional conservatives who tried to keep that bill off the House floor for 14 months, okay, with obviously Democrats, against that bill. But they're not debating any of this arbitration stuff. And by the way, neither did the Democratic majorities when they were in power, so don't fool yourself, okay? Nobody's really talking about lowering the cost of trial here. They're talking about taking away rights, preempting, allowing Iqbal Twombly preemption, allowing federal preemption of state laws and state juries.
Arthur,
Andrew makes a distinction here.
I was going to say, the one rule that sort of is less talked of than Rule 8 is Rule 1, which talks about a just, speedy, and efficient resolution being the purpose.
He would say just to his clients.
No.
I mean, no one else. I mean, I have to confess, when I read Rule 1, no one here doesn't know my philosophical orientation, but the truth is, it's a triad of values that speaks to both sides of the V. And he would say it's unjust.
What's unjust?
That your clients are subjected to frivolous litigation or extortionate litigation.
Well, I think I'm sure some claims are legitimate, some are not. The problem is we've got a system that's so expensive that it can't sort them out in any efficient way.
Even if you
that is the fundamental problem.
The economics of this are that if you win, you're just a little less ugly than if you lose.
I realize there is a great divide between you and John. But did you hear the statistics he gave you earlier? It happens to be true that in 40% of all federal civil cases, there is no discovery. But we're still booting them out on the Twombly-Iqbal.
Well, I don't understand what you're saying.
I'm saying that we have constructed.
To dismiss and there's no discovery? That seems unlikely.
I'm sorry, 40% of the cases have no discovery event.
That survive a motion to dismiss.
Right. Period. Period.
Because the
Period.
claims are strictly legal?
No, all I'm saying is when you, Andrew,
When I
when
sue
you
the government
talk,
about whether their restriction on lobbyists is unconstitutional, there's no discovery because it's a summary judgment, it's a legal question.
and there's no discovery in mortgage foreclosure cases. All I'm trying to suggest to you, and statistics are obviously deceptive, is that policy is being made, given the nature of the federal judiciary these days, on the basis of this slender band of big cases, which obviously is the playpen you are in.
Well, and a lot of other people.
And a lot, yes.
I don't
It's
wanna
not
be
the
the playpen
playpen that
myself.
Paul's in, though.
Well, no,
Sometimes.
Paul is brings class actions. It certainly is the playpen he's in.
But I also bring individual cases, and there are a whole bunch of cases involving all sorts of different consumer settings, and also a lot of individual employment cases that are getting swept into arbitration clauses right now as well, disappearing. And in the consumer setting, in the employment cases, at least some of the cases go forward. There are actually people who litigate individual employment cases and individual securities cases in arbitration. In the consumer setting, the cases just disappear, with the exception of about 1,000 total.
Let me ask you this, how do you deal with Andy's point that, given the AT&T clause, right, and all the bonuses that are available and attorney's fees, 99 times out of 100, isn't AT&T going to give the guy the $50, and so the individual gets whole? They get what they want. What doesn't happen is money doesn't get diverted to a third party, namely the lawyer.
Okay, here's the AT&T model. Say there's 1 million people who are each cheated out of $100. Okay, of the 1 million people, the number of them who figure out that they were cheated out of $1 million is 1,000. So you start off with 999,000 walking, okay? Of the 1,000, the number who gets so angry that they're actually going to do something is about 100. Of those 100, the number who can actually get a lawyer and go forward, they go and they get AT&T's amazing clause, and all 100 of them get their $100 back, okay? What a hell of an economic system we have. So you have a company that cheats 1 million people out of $100, and we've got a system that gets 100 of them all their money back, and everyone else gets nothing. That is the point of the AT&T bells and whistles. You know, we did discovery in a case in which a district judge found that based upon an enormous amount of evidence involving AT&T's clause of its amazing bells and whistles, which essentially amounted to like better mattresses in the jail cells, what the judge found was that an infinitesimal number of cases.
Jail, Andy.
You missed the phrase. The judge found, based on the evidence, that an infinitesimal number of cases would ever go forward in arbitration, even with AT&T's bells and whistles. And what the Ninth Circuit just said was, that doesn't matter, because under Concepcion, the fact that nobody gets a remedy doesn't matter. As long as it's infinitesimal, that's good enough. That's the post-Concepcion world.
Well, you can't ignore the Second Circuit in American Express 3.
The Second Circuit is the one...
It's going back up. It's going to go back. Ira, you're leaning forward.
Well, say is that regardless of the fact that the number of cases that go to trial are small, nonetheless, the fact that there is a potential that it will go to a jury, I think, impacts upon the way both sides try to work the record. And I think that you have Congress passing statutes protecting investors and protecting consumers, protecting workers and so forth. And I dare say that both sides understand that if there's a jury trial, they're going to work it and try to create the record in a certain way, as opposed to if it's an individual an arbitrator or a judge, you try to determine where his policy preferences are. And I think that that impacts upon the way the law gets developed, whether it supports congressional intent with respect to these particular statutes, or it gets skewed in a way that Congress didn't intend.
All right, Arthur, I got to come back. I had my sidebar point from before, because one of the big things in this, and I want to do the sidebar and then a big comment about Andy's. The factual point is that one of the reasons this little band of cases has big costs is because it's against gigantic entities. If you take the top Fortune 500 companies from America in 1955, post-World War II, industrial America, General Motors, Dow Chemical, you take all 10 of the top 10 of the Fortune 500, employed fewer people than Walmart employs today. One of the reasons driving this is that, and driving costs, is simply the size of the entities that you have to sue if you're a plaintiff. All right, but I want to come back to the point that Andy made, and this is an important major constitutional point, especially in this room. We think of the Bill of Rights. We're all children of the Enlightenment. We think of the Bill of Rights as restrictions on the power of the state. The Seventh Amendment, the right to jury trial, and the right to jury trial in the state constitutions is a mechanism for direct control of private power, not simply state power. You have to, that is the right way to conceptualize the right to a civil jury trial, that you have citizen jurors being involved as direct decision makers in disputes involving private entities. It is different from the other pieces of the Bill of Rights.
We have two Andrews here. Maybe three. You're nodding your head. Are you nodding your head? You agree with this?
My name is Andrew, but yes. But I agree that...
That's what I said.
Right. I agree that it's whose right? It's the citizen's right to participate. I think what we learned from this panel is if it's left to the lawyers, the jury trial will die a slow death. If it's left to the courts, a jury trial may die a slow death. If it's left to the legislatures, a jury trial may die a slow death. And the question is, who can stand up? And obviously there are certain lawyers in this room who believe it. In fact, I think most people have echoed the importance sort of symbolically that this is important, but they haven't isolated where that power comes from or how you can empower someone to push the buttons of power, right? Part of the reason why we trusted the citizens before was we recognized if we empowered them, they may actually have a role not just in juries, but in voting, being elected officers. That this was the, de Tocqueville idea of creating the skills of democracy so they could be active people to go to their legislators and say, we want to serve on more juries. We want to have a say against Walmart, or we want to have a say against the U.S. government. We want to be involved in this. But that voice is being silenced, and sadly, those same power players, I won't say it's only if you've gone to law school, but it's only if you either sat on a jury or gone to law school or seen juries in action that you appreciate just what a powerful and important institution it is in a larger democracy. And the question is how all of these people, and everyone in this room is a potential juror, right? Think about that. Every single person in this room is a potential juror that can go spread the gospel of jury service out there. And yet I will bet you each $100, no one will go do that, except maybe me and a few other people. But no one's going to do that, right? And the question is why and how you change the dialogue in America so that you can have these pressure points. Because guess what? The lawyers arguing back and forth isn't going to do anything.
So you like de Tocqueville?
I'd love de Tocqueville.
Even though he's French.
Yeah, but he understood America. And John Gastel out in Washington State has done some great work showing that jury service, you sit in a criminal jury through verdict, you are more likely to vote, you're more likely to participate in other active engagements. Like it actually has, Tocqueville was right, that it has an active thing. The idea that you sit through, you're a lawyer, you've gone to law school, but you sit through one murder trial and suddenly you're a believer is striking, right? Why weren't you a believer before, and how do we get everyone else to be that type of believer?
Chris, you've been listening to this. I think you've been listening to this. You want to add anything?
I will say this.
Microphone.
Give me the mic.
So, a jury trial is just like, congressional approval, right? It's so low, it's 13%, but your congressman's wonderful. It's like congressional approval. It's 13%, but everyone loves their own congressman. The same thing with the jury trial. Everyone hates it. Everyone thinks frivolous lawsuits, of course, until something happens to them, and you have to explain to someone on the phone, oh, by the way, there's really nothing you can do, because you have this arbitration agreement, for instance, and there's really nothing you can do. That's impossible. I can do, So, and it's the same thing, sitting on a jury. Jurors care when they're involved. The importance of the system, I think it has to touch you before you see how important it is. But, to think that, for instance, the expenses. Why is it expensive? 30 years ago, judges looked askance at motions to dismiss, not like I was even a lawyer at that point, but I can tell you that the judges that are still around, some of them still hold that point of view. Come on, motions to dismiss. Let's get going with a little discovery. Let's do a narrowly tailored document request. Let's see what's there. But now, we have to file 400-page complaints to survive motions to dismiss. And then as soon as you get beyond that, now we have 3-day class certification hearings where defendants 20 years ago used to stipulate the class certification in securities cases, because how could you not have class certification in securities cases? But now they're going up on loss causation, on materiality, on all these different things. So who's made the system more expensive? Who's made that process more expensive? Defendants have.
They
not
bill
plaintiffs.
by the hour. You don't.
That's right.
Well, on that happy note, all right, come on, you're part of this. A hand, a live hand.
I guess from the broader issue that's being addressed here, we've heard a lot about sort of the fundamental nature of this jury right and how it's essential to democracy and democratic access. But there are very, very well-functioning democracies in the world that do a lot of things better than the United States does that don't have the jury trial. So I'm wondering how the people who've sort of expressed this view that the jury trial is the sort of essential aspect of democratic policy and togetherness and getting people involved. How would you respond to the fact that it's not like freedom of speech, it's not like freedom of the press, it doesn't really seem to be essential because there are a lot of very well-functioning democracies out there that don't use it?
Andrew?
That came up actually in the course of the debate in Pennsylvania on the ratification of the Constitution. There's rather extensive remarks, and I invite everybody to read the book Ratification by Pauline Maier. It's a great book about, we have now a 20-plus year long history on the ratification of the Constitution that's still ongoing and still uncovering and compiling the minutes and notes of what actually happened in state debates. Our founders rejected the notion that a civil jury trial was not essential to the liberty. Madison described it as essential a right as any other of the pre-existing laws of nature. All of our founders, John Adams, Thomas Jefferson, George Mason, Edmund Randolph, and Rutledge, three of the men at the Constitutional Convention refused to sign it, and it was George Mason of Virginia who wrote a key article, Lost in History, Objections to the Constitution, in June of 1788, that led Jefferson to write Madison saying, you have to do something about this. And Madison then introduced, depending on how you count, between 17 and 20 amendments in the first United States Congress, of which the Bill of Rights survived. And the Seventh Amendment right to a civil jury trial was the only one unanimously approved by all of them. So
the framers would have had no idea that there was this ugly, expensive thing called ESI, and so therefore, that's lovely, but that doesn't go to the real costs of the litigation today.
The framers... I would say that I agree with this gentleman. I would say you can run a free society and have patent cases decided by expert judges, and it may be a more prosperous society.
Oh, there were admiralty judges and an admiralty court that the framers recognized, but they were loath to create specialty courts.
One other point that goes to a point that was made earlier. The Seventh Amendment has never been incorporated. So the vast majority of court systems in this country operate without compulsion of jury trial for civil matters.
But it's in all their state
No, it's in all the state
constitutions.
constitutions.
I understand that without federal compulsion of it. That's true. They can do whatever they
Well,
want.
that may be one. The Seventh Amendment hasn't been rejected either.
No, but some states tried different tribunals for different claims, medical malpractice claims, automobile claims. They're allowed to do that.
And the Second Amendment wasn't incorporated until a few years ago.
And liberty doesn't die when they do.
I love it when they talk dirty.
There's one other difference between us and...
The point that's been made in a curious way is the British were smart. They didn't write it down. We did. And that's the only difference.
But the founders had experience with the Star Chamber of the 1600s in which criminal trials were held behind closed-door rooms, and that's one of the reasons why they really loved jury trials, because they knew the power of the state behind a closed-door room or in a black robe was dangerous to liberty.
Okay. Other hands. Hands, yes.
Yeah, I think there are a number of issues that sort of surround this but are not directly there. One issue is what's happening to state Supreme Courts when you have millions and millions of dollars spent by special interests, and then you have judges who decide regularly on one side of the case. So you have that corruption. I do think the jury system or the legal system in terms of revealing abuse is very important, and the arbitration system is one way of stifling it. No, you won't be happy with this, Arthur, but the system of protective orders is another system of keeping information from the public. We have all these issues now about hydraulic fracturing, and a bunch of cases have been settled, and it's all under secrecy, so you don't have the information available so people can judge. So another thing that's going on is we have propagandizing of the public with reference to the jury system, and propagandizing of the sort that went on in the McDonald case, for instance, and others, which is, distorts the panel that you get to choose from. So we really face a multifaceted attack from special interests on what ought to be a jury system, and a system that supports and contributes to free speech and democracy.
Steve, well, hang on a second, Steve.
Can I come back to say something about the guy here about European systems versus the U.S. and jury? Because you got an answer from the 17th, 18th century. I think if you haven't noticed,
where's the mic?
There are some cultural differences between us and the European civil systems that I think you're alluding to. To put it one way, historically, those systems evolve from people who had the book read for them and had a central authority tell them what to believe. Our system evolved from people who read the book themselves and decided that they would decide for themselves what to believe. That's a major cultural difference. We're a common law system, that's a civil law system. And the jury trial in the Constitution, in the constitutions, is an embodiment of that cultural difference.
I didn't know Britain was a civil law system.
Well, Britain.
Just a little point. Go ahead, Steve.
Well, you're talking about the Brits.
I don't have the time to debate whether we should have juries in civil cases, but assuming we should, because it provides our citizens, our fellow citizens, such a wonderful experience. I mean, they really love it. People love to serve on juries, and it's great for them. It's great for the public in the United States to have that opportunity. We ought to focus our attention on how do we make them cheaper, because there's no inherent reason that a jury trial has got to be more expensive than arbitration. And the second thing is, how do we cause people to have more trust in what juries do? For example, the patent cases that Mr. McBride is talking about. You could have a jury of people who are scientifically oriented, special juries, but more than one person. The problem with jury selection, voir dire problem. Why don't you have juries of 20 people with a requirement of 15 out of 20 to return a verdict? No voir dire, no questionnaires, people off the street. We have done so much in this country to make jury trials incomprehensible. They aren't instructed preliminarily. We don't allow questions. We don't allow interim argument. The judge charges them in federal court after the lawyers argue rather than before the lawyers argue. If they're in deliberations and they want to see something or hear something, the judge says, don't bother me. They're so in a hurry to get it done. Use your memory rather than sending back the transcript, which they could readily do. I mean, we have made it so that people just reasonably distrust juries. These are law reform things that we as lawyers can focus on, reducing the expense. We don't have to make it zero, just as cheap as arbitration, and make it as predictable as arbitration. And you can easily do that because all of our experience with mock trials shows how really predictable juries are, as easily as predictable as arbitrators. And so we just have to get the word out there.
Can I just add to what Steve is saying, because I think that I'm right. It's Joel.
No, I'm looking to see if they're
You know, we've talked a lot, and we could debate all day about what the problems are. Okay, but something that we haven't done is talked about how to fix them, because for the time being, the jury trial isn't going anywhere. Okay, at least for the foreseeable future. So I read Steve's article with great interest as well, and I echo David's sentiments, that it's an important article for everybody to read. Because the reason why it costs so much is because it takes so damn long to get there, right? And if discovery was sped up and you could actually see the light at the end of the tunnel, we just did in a focus group last week. We asked jurors, what is the first thing that comes to your mind when you hear lawsuit? When you hear headache, oh no, lots of money, how do I avoid it? Why? Because it takes so long. You need to have perseverance. You need to really dig your feet in and be ready for a big fight. So what can we do to change it? I mean, on my side, every time I have the chance to beat the drum loud and proud, whether it's a federal judge or a congressman or a senator, I say, how are we living in a country where you don't get to ask questions of prospective jurors? And when people's life, liberty, and their finances are at stake, you're cut off at the knees, and you're told, no, that doesn't matter. Or you can be fair, can't you? How many times have you heard a judge, when someone says they're biased, they say, I understand you have an opinion about that, ma'am, but you think you could put it aside? And I'd be remiss if I didn't give him credit, but Roy Black said to me last month, I always want to ask the judge, where are they going to put it?
Okay.
Put it where?
Question here.
We've heard ESI held out as this boogeyman that creates costs. Of course it does. But why can't litigants and judges work together to limit the scope of discovery to the most relevant issues and to use information technologies to sift through ESI to efficiently find where that most relevant material is stored?
We can, but there's a basic distrust that exists.
Well, it's worse than that. It's funny because we talked about criminal versus civil. A lot of the criminal questioning happens in the courtroom, in front of the judge or in front of the jury. People are more honest. And in the civil context, you're in a deposition. And recollections are weak. And the problem we have as plaintiffs' lawyers is you really need the discovery. And it's hard. And the other side doesn't want to make it easier. They want to make it harder. They want to keep it from you. So you have these battles, but those battles are everything. Because if you don't have the documents, you're not going to get the testimony. And that's the problem.
Also, this area is rapidly evolving. I'll tell you, if you look at key term searches in relation to predictive coding and some of the other advanced search technologies, a lot of judges don't understand it. A lot of litigants don't understand it. You need specialized knowledge, IT consultants in particular, particularly in large cases. And I think we're in a period of transition where all of that will evolve, and the FJC and other federal judge organizations will start to adapt standard practices in that area.
Yeah, if you thought that the rule makers were done with the SI in 2007, you're wrong. That was a first generation shot at the rules. And as Adam just said, the technological capabilities for search are just extraordinary and escalating. So maybe it'll bail us out. Anyone else? Anyone else? Yes. Microphone.
I was just curious about Mr. McBride's point about I guess he was saying the fundamentality or the difference in how fundamental the criminal versus civil right to jury is because of the confrontation clause. But a lot of that, I guess I was questioning, is because I think the point is that a plea bargain is so different than a negotiation settlement. And so I guess the question is, it's true that in both realms, jury trials are extremely rare. But do you think that it's a problem, more of a problem in one versus the other for, the stakes at hand?
I think, I was a prosecutor for 10 years. I was not a big fan of the sentencing guidelines. And what was said about the sentencing guidelines jamming people into not going to trial is true. And it made the prosecutor almost too powerful for a 28-year-old kid, honestly. And that's, people don't go to trial because when you're looking at life without, the only way out is, acceptance, cooperation, and a Rule 35 motion. That's what you're going to do. And that's what any good lawyer would tell you.
Yeah, the sentencing guidelines were really a problem, except just before them we had an issue where if you had a black person who committed a crime and a white person who committed a crime, you could tell for the fairly high percentage how much more likely one was to be convicted than the other, and it turned out it wasn't the white one. And so the sentencing guidelines were a response to the fact that over a whole bunch of decisions, you had very terrific statistical evidence that showed recurring racism in judicial sentencing. Now, this was before Walmart versus Dukes told us that no statistics that show things like racism and sexism should be considered. So the Congress did, I mean, the sentencing guidelines may be a lousy system, but it was just, it was a response to a very real social problem.
All right, the management has asked me to remind you, right after this session is a networking lunch. Then you've got a conversation on perspectives and federalism with Judges Kaczynski and Reinhardt, otherwise known as the odd couple. And at 6, you've got Justice Ginsburg. Now, both the odd couple and Justice Ginsburg's presentations are in the presidential ballroom. My thanks to this panel and their ability to remain civil, if not noisy.